Bill Henshaw here again, continuing with my YouTube videos on current events, and in this case, my 5 basic documents in my trial court packet. And you can get information on all of my packets. Send me an email, youwinincourt@gmail.com. And this one we're going to cover is a brief on the 14th Amendment, which for those of you who don't know, and most of you don't, 14th Amendment does not exist, and it never has. Yet that's the only jurisdiction these bastards have in any of these so-called courts, which are federal legislative territorial tribunals, not state judicial courts. And that ratification with a capital R-A-T of that amendment is what I call a gargantuan, grisly, gruesome, grand slam of violations of all 6 articles of the Constitution. For openers, in the 39th Congress, none of the southern states were represented in either the House or the Senate, despite the fact that the plan developed by Abraham Lincoln and employed by Andrew Johnson was in place, and Congress submitted the 13th Amendment to the state legislatures created under this plan, and most of them approved the amendment, and it became law, and it abolished slavery. Now, if that's the case, that's an overt admission by Congress. These states are back in the Union. There's no 2 ways about it. And yet, when they sent their senators and representatives, to the 39th Congress, and actually the 38th one too, they were all rejected without even a hearing, summarily, and kept out. So therefore, when Article 4 of the Constitution, or Article 5, excuse me, of the Constitution says that 3/4 of the Senate and the House are needed to propose an amendment, there wasn't a quorum to do business there, because with the southern states out, you had 11 states there, and we only had 38 at the time, and they couldn't possibly have had a quorum to do that with 75%. I mean, this is a big deal. Think about that consent of the governed. Where the hell is it here? It's not. So not only it couldn't be proposed, but it couldn't be ratified in the way it was, because again, what happened was that all the southern states rejected the amendment in sufficient numbers to defeat it today, let alone in 1868. And it wouldn't have become law. But that prompted Congress to pass the Reconstruction Act of 1867 and create military legislatures, and they were the ones that ratified the amendment. Hence, the 14th Amendment is nothing but a war act of Congress, plain and simple. And it explains a lot of things going on even today, 150 years later. So that's where we are on that. And my goodness, in fact, you look at Section 5 of the 14th War Amendment, and it says that Congress can pretty much pass any law that it wants with regard, to their new citizens. And by the way, the secret intent of that amendment was to make citizens out of corporations. Nobody outside the secret committee of 15 on Reconstruction had a clue. Consent of the governed, where the hell is it, even if it was otherwise properly ratified? But it wasn't, because it couldn't have been ratified by state legislatures. If, in fact, that was an attempt to add to the sovereign body politic of the nation and republic, and many people might have misconstrued the amendment to just that effect, it would have to be passed by people in conventions of the states. Our agents can't make changes like that. It doesn't work that way. That comes from principles. We're the principals, they're the agent. We tell them what to do. So notwithstanding whatever happened with these war legislatures, it still isn't valid. And there's a lot more to it too that goes into that. I mean, all 6 articles, Article 1, 2, 3, where you talk about racial representation in Congress. And again, without the southern states there, they're already in enough trouble on that ground. But when you realize that 1, 2, 3 sets the maximum ratio of representatives to inhabitants at 30,000 to 1, they would have needed something like 1,500 or 1,600 people in the House of Representatives. And they had maybe 20% of that. Well, okay, a little more, but maybe 25, but not even anywhere close to a quorum to do business. Another big deal issue that's never, so far as I've been able to find out, been litigated anywhere, and I've been at this for 5 decades. I haven't seen it. So that's another one. And then Article 2 with the president, with the states admitted after Minnesota and Oregon in 1859, the president has made declarations of admission to the states to the union. But the problem with that is he doesn't have any authority in that area at all. Article 4, Section 3, admission of new states, that's Congress, not the president. The only way it makes sense, and here again, the 14th Amendment is a war amendment, right? President's commander-in-chief of the armed forces. What exactly is he admitting as a state and to which union? Whoa, you start asking these kinds of questions, it gets interesting in a hurry, and that's what I'm doing in this brief on the 14th Amendment. And saying to the black robe badgers and the local dumbasses, the problem you have is you've got no jurisdiction here, and we can prove it. And not only that, we're unopposed here. The DA having the sworn duty to be bound by this Constitution and laws enacted in pursuance thereof has never opposed any of the documents I present, specifically this one. There's no way to do it. They cannot argue the 14th Amendment. That beats them from day one. And that's what we need to do if we run a judicial court with common law. That's a slam dunk. Simple. Fourth graders would get it. We're not there. We have to get back into state courts, not federal territorial tribunals in which our status and rights are not recognized, let alone any of the 6 articles of the Constitution. So that's what this writ's designed to do. There's a lot of information in there. It is not me saying it. Okay, I get it all from the Supreme Court of the United States, the framers of the Constitution, and other stellar authorities like that. They're saying it, not me. So you start making arguments like this, it gets interesting in a hurry. And the bottom line is they instinctively know that if we're right, that they're sitting there in official positions, but not acting officially because they're not in office. And again, if the states or territories, guess what? All those badgers have to be appointed by the president and or a territorial governor appointed by the president. That's the appointments clause, Article 2, Section 2. Geez Louise. So it really almost too much to comprehend initially, but when you have that aha moment about there being no states, a lot of it comes together quickly. So I want you to study this document when you get my document packets and send me an email, uwinnincourt@gmail.com. I'll send you information on how to do that. And this is a winner chicken dinner from day one. So that said, be sure to like the videos, subscribe, tell your friends, get the word out. We have an unprecedented opportunity here to make serious progress in getting these New York gangster bastards off our back and getting rid of martial law rule. May never have it again. I think we have a good 6 months here until they maybe come through with this COVID vaccination that's going to be compulsory. And then martial law gets really interesting in a hurry because a lot of people are going to want to protect their kids from this vaccination that they don't know what the hell it is and this, that, and the other. But that said, the quicker we act and the more of us that do it, the faster we win the battle and get our government back. Thank you.